Thank you, Jim, and good afternoon, everybody. As Ms. Wallace said, there's a learning process going on here, and I learned something this morning. I learned that it's a good thing that I had the note about me being a CFL arbitrator on my CV because Mr. Antle and Mr. Erdl said that when you're choosing an arbitrator, do not choose a retired judge. So when I retire, remember that I am or was a CFL arbitrator. Thank you for the invitation to address you. I hope I don't touch on matters which are mundane. I know there's a broad cross-section of people here from every area where ADR is involved. I want to talk about what has happened in our court in the past and what is happening now, and a bit about the future. JDR, or Judicial Dispute Resolution, in our court has been practiced formally for over 20 years. Before I get into its origin and history with you, I want to tell you a story about one particular matter in our court. After a day and a half of evidence in a trial, one of our judges called counsel into chambers because the issues hadn't been articulated clearly, if at all. And after the judge heard what was really an issue, he strongly suggested that it bordered on lunacy to continue with the trial, and suggested that the parties immediately go to a judicial dispute resolution in front of another judge. Both parties were represented and counsel agreed. The report of the judicial dispute resolution judge was as follows. There was a housing development. It was marketed as a mini-gated community. There were 50 large estate homes sold to homeowners. They agreed to, belong to, and pay fees to a homeowners association. And that association had the responsibility for lawn cutting, tree pruning, and general aesthetic maintenance of the area. No one disputed these were the terms of the purchase and sale of the houses. No one disputed that the association was in control of these matters and that the individual homeowners had agreed to it. The dispute was about the tree cutting. The defendants in the action were husband and wife homeowners, one of the 50, who did not want the trees cut around their home. The association refused their request not to cut the trees because they wanted to keep control of the aesthetics by restricting the height of the trees so as to preserve views and replace certain others. The defendants refused to pay their assessed fees in the amount of $100 in protest against the tree cutting program. The homeowners association then sued the defendants for $100. The defendants barred the association's maintenance person who was going to cut their trees from their property and hired their own maintenance person to do their work for a short period of time. They paid the other maintenance person $350 and not only defended the claim for $100 but counterclaimed for $350. Why was this action in the Court of Queen's Bench at all, you might ask? Well, pursuant to the agreement signed by all the homeowners, containing a term about non-payment of fees, the association filed a caveat on the defendant's land title and proceeded to foreclose the property. Foreclosures, as you know, must be heard in the Court of Queen's Bench, or the Superior Court, I dare say, in other jurisdictions. Counsel agreed with the JDR judge that the most they could hope to achieve was a $100 judgment if the case were to be won by the plaintiff, and a $350 judgment and a dismissal of the plaintiff's claim if the judgment were to be won by the defendants and plaintiffs by counterclaim. It's disturbing to me that this case was under case management. The parties flatly refused to have the matter mediated or otherwise submitted to JDR or any form of ADR. Second, the parties had engaged in, get this, 11 days of oral examinations for discovery. Third, and most astonishing, the Homeowners Association's legal fees up to the trial date had climbed to $150,000. The trial was set for 2 weeks. The defendants had expended $30,000 in legal fees to the date of trial. Ironically, the Homeowners Association assessed all of the 50 homeowners, including the defendants, for the association's legal fees in the amount of $3,000 each. And the defendants paid the $3,000. The JDR judge was able to get the parties to agree to a tree-cutting protocol which was acceptable to all. This is less than a day that he was successful in getting them to agree on a settlement. But he went further. He had a private meeting with counsel, and this is controversial, without the clients, and asked them what he called the front page of the newspaper question. That is, did they believe the public's confidence in lawyers would be enhanced by reading about the amount of the legal fees charged in relation to the amount in issue? More fundamentally, how had this situation been allowed to happen? Counsel admitted that they had, quote, let it get out of control, but they somehow could not stop the train, end quote. Each blamed the other. Nevertheless, the defendants indicated they were going to seek indemnification for their costs. At this point, the JDR judge indicated that he had a concern with the legal fees charged to the association. He suggested counsel for the association should consider refunding part of the amount they had been paid because they had a responsibility to their client to ensure proportionality. He suggested association counsel return 1/3 of the fee, and his persuasive powers resulted in the return of 1/3 of that fee. He also suggested that defendants' counsel should refund part of what was charged, and they should give that amount to the plaintiffs on the basis that had the case been tried, the defendants likely would have lost the action. Defendants' counsel ultimately agreed to put $20,000 towards the settlement. The result was a total reduction of fees of $70,000 and a tree-cutting protocol. I'm going to quote to you the report of the JDR judge, but before I do that, before you're probably wondering, I want to make it clear that because JDRs are confidential in our court, I don't know the names of the parties, nor do I know the identity of the counsel, nor do I regularly receive any reports or any communications about JDRs conducted in our court because they are confidential. But I specifically asked for a report after hearing an oral report as to why a 2-week trial had been aborted after a day and a half. So I'm going to quote the JDR judge's report. Quote, 2 matters to think about in terms of the role of the court. I believe on occasion we should step in when our gut feeling is this trial is ridiculous and should not be going forward. Obviously, we must be very careful in this regard, but surely that decision is ultimately part of the court's authority to control its own process. The second is more problematic. In the final analysis, and these are his words, I did beat up on counsel to some degree. I did not do it in front of their clients. They did convey some of what I had said to them about their role to their clients as a contribution by them to become part of the settlement. I don't know how they put what I said to them to their clients. My concern is that we should not be seen as policing the bar, and that is ultimately the responsibility of the bar. However, I do believe that if we have a little more flexibility in our arsenal in the JDR context, that we can probably do things in this role we could not do in a courtroom. So what lessons do we learn from this anecdote? First, some civil litigation is out of control even when it's under case management and when JDR and ADR are available. Second, most of these problems cry out to be solved earlier rather than later. Third, proportionality of cost in relation to the value of the matter in dispute is a fundamentally worthy concept, and that's since been articulated by every court in this country, I believe, under the guidance of the Supreme Court of Canada in the last couple of years. Fourth, there may be some merit to limiting the availability of system resources depending on the kind of claim in issue. I've chosen to speak to you about JDR at our court because I think this form of dispute resolution heralded a turning point in the administration of civil justice, at least in Alberta, that began in the early 1990s. Originally, it arose out of what is called the judicial mini-trial. The judicial mini-trial was a non-binding process where two counsel would go in front of a judge and ask for a non-binding opinion based on written materials only. The object was to reverse the lead times for trials, which were getting longer and longer. The causes of those increased lead times are several, and we're still grappling with those fundamentals today. They include the hyper-legalization of society, the attendant increase in the number of litigants without counsel, the increasing complexity and length of trials, and therefore their cost, and the reluctance on the part of government to provide the courts with resources to keep up with burgeoning volume. The Court of Queen's Bench in Alberta has been conducting some form of dispute resolution in Alberta since 1991. Case management continues to play an important part within the framework of the management of litigation, but in a different way from the JDR program. Case management is used to help identify the issues and procedures to be used, leading to a trial, while the aim of a JDR is to avert the need for a trial in whole or in part. On occasion, case management may result in a settlement, but it is not designed for that purpose. In contrast, our JDR program provides a party-initiated framework for a judge to facilitate a process in which the parties resolve all or part of a claim by agreement. It is an effective cost savings mechanism and well-liked for outcomes which benefit everyone involved. It differs from private mediation programs chiefly because JDR is conducted by a judge, and you don't have to pay for the judge. It is also done only after a proceeding is commenced in the Court of Queen's Bench. It usually involves a rights-based approach, that is, an evaluation of the legal rights in issue. How is this program accessed today? It's been reported that when Abraham Lincoln was asked the question, as you know, he was a lawyer before he was a politician, a trial lawyer, he was asked the question, well, would you rather try a case before a judge and jury or a judge alone? And his response was, well, who's the judge? The JDR program offered by the Court of Queen's Bench allows the parties, by agreement, to pick their judge. There are, of course, some limits to this. If you go to our public website at albertacourts.ca and then to Court of Queen's Bench, there will be a section entitled Assignments. And under assignments, for a given term of the court, that is January to June, or the summer, or September to December, the JDR judges assigned for any particular week will be listed by date and by day. The parties can choose any day that has not already been booked for their JDR and then book it with the JDR coordinator in Calgary or in Edmonton. A similar process, not online, is offered in our other judicial centers. And for those of you not from Alberta, we sit at 13 different points in Alberta, including Calgary and Edmonton. The point is that it was always contemplated that the judicial mediator could be chosen, subject, of course, to the consent of the judge. Because the underlying premise is that it is a consensual process, the parties should be able to choose who is going to do it. Also in Alberta, from 1969 to November 2010, we had rules of court which were utterly silent on judicial dispute resolution. In 2010, with the advent of what was called then the new rules, the purpose was stated, that is for judicial dispute resolution, to provide a party-initiated framework for a judge to actively facilitate a process in which the parties resolve all or part of a claim by agreement. These words were chosen carefully. The platform once set supported a rule that judicial dispute resolution process could generally be initiated only by agreement of the participating parties, subject to the direction of the presiding judge. A number of things are directed to be agreed upon in the rules. One, that every party necessary to participate in the process agreed to do so, barring a good reason not to agree completely. Two, that the guidelines would include a definition of the nature of the process, that is, the matters to be dealt with during the process and the manner in which it would be conducted. That's agreed upon before the process is started. And of course, the date and location. Also, the role of the judge and any outcome expected of the judge's role. Three, whether materials would be exchanged before the date, who would participate, and an express proviso that participation must include persons in attendance or in some cases on the telephone who have authority to agree on a proposed resolution unless they're relieved from that obligation. And it is embodied in the rules that the parties who agree on the process are entitled to participate, and that the parties may request a judge named by the parties. Further provisions of the rules embody the obligation of confidentiality and the use of information. There are specific provisions that statements made or documents generated, unless otherwise agreed upon, are privileged and are made or generated without prejudice. Nothing is admissible in a subsequent application or proceeding in the same action. Only documents that arise from a judicial dispute resolution process are the agreement prepared by the parties to resolve it, if they do resolve it, or a consent order or a consent judgment resulting from the process. The parties of the two litigation under our rules have the responsibility to manage their dispute. That responsibility includes a good faith participation in one or more of the following dispute resolution processes. This is in the new rules. That is, a dispute resolution process in the private or government sector involving an impartial third person, a court-annexed dispute resolution process, a judicial dispute resolution process, that is a JDR, or any program or process designated by the court for the purpose of the rule. I want you to be clear on one thing, is that our court has no desire to compete with private ADR. Many of our cases are resolved before private mediators or arbitrators at the suggestion of justices of our court. Judges believe that people should have choices. Our objective, the same as all of us in the justice system, is to attain resolution, not just by trial, but by any means that will allow litigants to get a fair outcome and to preserve the values that might be important to them, not simply walking away with the most money. Sometimes an apology is all it takes. From our perspective, the JDR program has been credited with playing a large part in the dramatic reduction of the court's civil trial lead times, that is, the earliest date upon which a trial can be booked. In 1 decade, we reduced our civil lead times by more than half. The settlement rate for JDRs in 2001 was 80%. That is, at the time the JDR occurred. We don't know how many settled after that time and prior to a scheduled trial. But that settlement rate has remained unchanged today. That is the same reason that Martin Teplinsky, a prominent Ontario arbitrator, discovered that the Med-Arb process works better than mediation alone. At least that's his thesis, because, quote, once the parties know that a binding decision is imminent, they prefer the certainty of settlement to the uncertainty of an adjudicated result. Because the choice of engaging in a JDR is voluntary, the parties come into it already predisposed to talking about their positions, so that may play a part in the success of our program. But that's not to say it's always a good choice. For one thing, it's not likely to succeed where one of the parties is intransigent on a crucial issue, or where the case has gone on so long that the parties have become entrenched in their positions. Also, where parties do not provide full disclosure, a judge may not be able to provide an evaluative opinion. It's not always a suitable process if credibility of some key participant is an issue. It's difficult to conduct an effective JDR without counsel, since the enforceability of an agreement may depend on independent legal advice. And by the way, when we do conduct a JDR with a self-represented person, it is on the record. It is not with counsel, but it is with a self-represented person, and that record is sealed, subject only to unsealing by order of the court. That is very rarely, if ever, happens, but we foresee that it could happen in the case of a complaint against a judge. The Canadian Judicial Council may ask for it, for example, or dare I say the Court of Appeal may ask for it for some reason or another. I'm puzzled by the fact that despite the plethora of alternatives, arbitration, mediation, settlement conferencing, brief conflict intervention, collaborative law, restorative justice, and judicial dispute resolution, that the legal profession is still thought of as being adversarial in the civil context. That was fine in a bygone time. The fact is, in common law jurisdictions around the world, fewer than 5% of civil cases actually reach trial. Some lawyers still prepare as though they were invariably going to trial. This is not to diminish the value of trials. Some disputes should only be settled by an impartial adjudicator. But for many disputes, this is a very expensive way of resolution, even if the litigants say that is what they want. JDRs may have also inadvertently created a different problem. Some critics say that we've shifted the burden of finding creative ways to resolve disputes from lawyers' shoulders to judges. And we do indeed have some experience with lawyers who forget they can be problem solvers. They don't talk to each other before they get into the JDR room, which is something of some concern to the court. Lawyers should have the ability to achieve positive solutions for their clients outside of court. As I indicated earlier, we do not regard ourselves as being in competition with private industry. We already have more work than we can handle, but we believe that most people want a cheap, expeditious resolution. We know that some people choose JDR, not just because of the cost advantage, but because of the imprimatur of a judge. Members of the bar have flocked to our program from its inception. In 1994, 6 JDRs were conducted in Calgary. A year later, 137 in Calgary and Edmonton. At the end of 1999, we became the first court in Canada to incorporate dispute resolution weeks into judges' sitting schedules. In 2008, we conducted over 700 JDRs in Alberta, and as its popularity arose, the JDR program began to create scheduling difficulties. As someone mentioned to me earlier this morning, you could get a trial date in a civil case, a short civil case, sooner than you could get a JDR date. Over time, we increased the number of judges assigned to JDR weeks from 1 to 4 in each of Calgary and Edmonton. And by 2013, we were conducting over 1,000 JDRs a year. We were becoming overwhelmed by the demand for the court services in all areas, including JDRs, and our lead times were getting worse. It became apparent that JDR had to some extent become a substitute for settlement discussions, and by February 2013, we made a considered decision that the conduct of trials within a reasonable time was one of our core obligations. We therefore suspended a requirement in our rules of court that parties requesting a trial must first have participated in a dispute resolution process, not necessarily a JDR, but one of the forms mentioned earlier. The result is that the number of JDRs we heard in 2014 went down to just over 700 in 2015, and I'm talking about fiscal years here that the government imposes on us, that they end March the 31st of each year. 2015, 528. So that's almost a 50% fall. In the fall of 2014, we reduced our assignments to 2 JDR judges per week in Calgary and Edmonton, which remain the situation today. I want to touch briefly upon some ethical issues. If you know judges in your jurisdiction or talk to them, some judges have ethical difficulties with judges conducting judicial dispute resolution at all. The bar may not have the same ethical issues, but I see some commonality in lawyers conducting JDRs as well, ADR as well as judges conducting JDRs. A quote from Chief Justice Warren Winkler, as he then was, of Ontario, summarized the issue. He said as follows, quote, "Some judges consider that it is inappropriate for them to engage in any form of mediation. They maintain that the judiciary is trained to decide cases, not to broker deals. Mediation, they say, requires them to descend into an arena, a place antithetical to judging. In increasing numbers, I believe other judges feel that judicial mediation is now part of the lifeblood of an ever-evolving system of civil justice, and we must have it to keep up with the changing needs and expectations of litigants. According to this view, to best serve the public, mediation must be an integral component of any modern and effective civil justice system." Most jurisdictions, that's the end of the quote, most jurisdictions in Canada have adopted alternate dispute resolution programs, but the shift away from judges presiding over matters in an adversarial system to their role as settlement facilitators has led to the emergence of new ethical issues over their role in the justice system. One of the key areas of controversy is caucusing, that is, meeting separately with one party or the other and their counsel, or from the other. The American Bar Association Code of Judicial Conduct codified the ability of judges to caucus. It says, quote, "A judge may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to settle matters pending before the judge," end quote. Some judges are concerned that conferring separately with the parties opens the appearance, if not the possibility, of coercion, which compromises the image of impartiality. Under the 1990 code, which preceded it, unlike the 1990 code which preceded it, the 2007 model code now addresses improper judicial coercion by setting out a number of factors that a judge should apply to assess the appropriateness of settlement practices. One of them is whether the parties and their counsel have consented or requested a certain level of participation by the judge. I can tell you that in Alberta, that is always adhered to. This is a consensual process. Everybody agrees on it, to the role of the judge, the role of the parties, and the process before it is done. Participation in excess of that level is problematic. Another is whether counsel and their parties are relatively sophisticated in legal matters. A third factor, in the U.S. at least, is whether the trial will be by judge and jury. This isn't a factor in Alberta because under the Alberta rules, a JDR judge, if the JDR is unsuccessful, may not be the trial judge, nor may that judge be involved in the case at all on subsequent motions or applications unless the parties consent in writing. The first stop to finding out how to conduct a JDR or settlement conference ethically in Canada, at least by judges of superior courts, is by reference to a document called the Ethical Principles for Judges, which is published by the Canadian Judicial Council. The problem with that document is that it was published in about 1996, before JDRs became popular or indeed prevalent in any court in the country notwithstanding that there was JDR going on in Saskatchewan, in Alberta at that time. Some legal scholars argue that these principles don't provide adequate guidance in the context of settlement conferencing, and as a member of the Canadian Judicial Council, I can tell you that new ethical principles for judges is something that's being actively considered now. That is, we need an updated publication. Another criticism is directed at the evaluative model of judicial settlement. The evaluative model is where a judge assesses the narrow legal rights of the parties and signals the likely outcomes in litigations. My personal opinion is that's one of the reasons parties choose a JDR rather than some other form of ADR when they're already in litigation. They get, if asked, the opinion on the merits of the case by the presiding JDR judge. And they can get that separate from the other side, or they can get it in a plenary session as a whole, again, depending on what's agreed on. My own practice is I never do that unless the parties ask for it to be done. I do not volunteer it. Critics also say the judge's position and authority could make it difficult for the parties, unless they're sophisticated, to distinguish between the judge as evaluating their chances as a mediator and the judge conveying the definitive position of the court. This approach or reproach was first expressed 20 years ago when the judicial dispute resolution was still young. It's lost some favor, I believe, because it's too simplistic an analysis. In reality, both evaluative and facilitative techniques find expression in a range of practices in the JDR room. Neither of them exists in undiluted form. And we still have available binding mini-trials or non-binding mini-trials. We use, especially in the family law area, because the bar asked for it, what we call the med-arb. You do a mediation. If that doesn't work, the parties agree to be bound by the decision of the judge. The Alberta Law Reform Institute questioned the authority of a judge to provide a binding decision which was not on the record. They said that the minute a judge gets involved in a binding mini-trial, she assumes an adjudicative position, not a facilitative position, which is what a JDR should be. I don't remember that. I was probably chair at the time. But in any event, that's found in a consultation memorandum number 12.6 when we were looking at the new rules. Even though one of our basic rules is that a JDR judge may conduct a trial only if they have obtained the consent of the parties, that rule has not allayed the concerns by some judges of the merging of mediating and fact-finding roles. As a remedy, the judges in our Edmonton Judicial District are required to conduct a pre-JDR conference to determine what the procedures to which the parties will agree are, and we do that as a matter of course in Calgary also. But it's generally perhaps more pragmatic in Calgary than the process-driven role in Edmonton. But these concerns all deserve respect. They're all significant. And as a court, we continue to refine our practices as the field evolves. I mentioned earlier that I believe people should have choices. The JDR program has proven to be a significant addition to the methods of improving access to justice. If we want people to be able to afford and access justice and have a quick resolution, the courts have no choice. We have now discovered something that the people and the bar want, a method that solves problems fairly and effectively. We need to keep refining an ethical framework that allows judges to be both adjudicators and mediators in a way that preserves the highest standards of the administration of justice, but without sacrificing a valuable means of resolving disputes. That said, I have asked our Rules Committee to expressly provide in our rules our court with authority to compel the parties to participate in a private mediation. We do not have that express authority now. I am advised that this proposal is out for consultation now. when, how, and under what circumstances a judge should order a private mediation will be the focus of the debate, which is under consultation. In closing, I wish all of you a successful and rewarding conference. If the rest of your sessions are any like the one I attended this morning, your learning experience will be excellent. Thank you.
Chief Justice, thank you so much for the insights and for taking the time with us. And as a small token of our appreciation, please accept this. Thank you.